Imagine a world where the government could follow your every move, not with a team of agents in trench coats, but with a tiny, silent device attached to your car. They'd know when you leave for work, where you go for lunch, who you visit on weekends. They'd have a perfect, unbroken record of your life, stored on a server, ready to be analyzed. This isn't a scene from a dystopian novel. This was the reality facing Antoine Jones, a nightclub owner from Washington, D.C., and the legal battle that followed would redefine what privacy means in the 21st century. This is the story of United States versus Jones, the landmark case that drew a line in the sand between government surveillance and your personal freedom. And it all started with a simple GPS tracker. The year is 2004. The FBI and the D.C. Metropolitan Police have their sights set on Antoine Jones. They suspect he's the kingpin of a major cocaine trafficking ring operating out of the D.C. area. They've been building a case against him using traditional methods, wiretaps, informants, and physical surveillance. But watching someone 24/7 is resource-intensive and often imperfect. Agents need to sleep, cars get stuck in traffic, and targets can be lost. They needed something better, something constant. They needed technology. So the investigators went to a federal judge and got a warrant. This warrant authorized them to secretly install a GPS tracking device on a Jeep Grand Cherokee registered to Jones' wife. But here's where the case begins to get complicated. The warrant had two specific conditions. The device had to be installed within 10 days, and it had to be installed in the District of Columbia. The agents missed the deadline. On the 11th day, they installed the tracker not in D.C., but in a public parking lot in Maryland. For the next 28 days, this small device silently beamed data back to the authorities. It transmitted the Jeep's location more than 2,000 times, painting an incredibly detailed picture of Jones's movements, his patterns, and his network. This constant stream of data eventually led them to a stash house in Fort Washington, Maryland, where they found nearly 100 kilograms of cocaine, almost $1 million in cash, and equipment for processing drugs. With this mountain of evidence, the case against Jones seemed open and shut. At his trial, prosecutors presented the GPS data as the cornerstone of their case, linking him directly to the drug conspiracy. Jones was convicted and sentenced to life in prison, but his lawyers saw a critical flaw in the prosecution's methods. That GPS tracker, installed without a valid warrant, felt wrong. It felt like a violation. They argued that this constant, 24/7 surveillance was a search under the Fourth Amendment, and since the warrant was invalid, the search was unreasonable. The government disagreed. Their argument was simple. Jones was driving on public roads. Anyone could have seen him. A police officer could have followed him. The GPS tracker, they claimed, merely automated what was already legal and visible to the public eye. They argued there was no reasonable expectation of privacy on a public street. This is a key concept in Fourth Amendment law. Since the 1967 case of Katz v. United States, the courts have used a two-part test. First, did the person have an actual, subjective expectation of privacy? And second, is that expectation one that society is prepared to recognize as reasonable? The government was essentially saying, no one can reasonably expect privacy on a public road, so we don't need a warrant to watch you there. The D.C. Circuit Court of Appeals didn't buy it. They overturned Jones's conviction, finding that the sheer volume and duration of the GPS surveillance was fundamentally different from a cop following a car for a few hours. This wasn't just observing a single trip. It was compiling a detailed mosaic of a person's life. The case was so significant, so foundational to the questions of technology and privacy, that it was destined for the highest court in the land, the Supreme Court of the United States. When the case reached the Supreme Court in 2012, it wasn't just about Antoine Jones anymore. It was about every single person who drives a car. The question was profound. Does the government have the right to secretly track your vehicle for weeks on end without a valid warrant? The 9 justices were faced with the task of applying an 18th century amendment to 21st century technology. The arguments were intense. The government's lawyer argued that the GPS data was no different from obtaining phone records or bank statements from a third party, which previous rulings had allowed. Jones' lawyer countered that this was a physical intrusion onto private property for the purpose of gathering information. A classic trespass. The court's decision, when it came, was unanimous in its judgment, but fascinatingly divided in its reasoning. In a landmark opinion written by Justice Antonin Scalia, the court did indeed even need to get to the reasonable expectation of privacy test from Katz. Scalia went back to the roots of the Fourth Amendment. He argued that the amendment was originally understood to protect people from physical intrusions by the government onto their persons, houses, papers, and effects. Your car is an effect. When the FBI agents attached the GPS tracker to Jones's Jeep, they physically occupied his private property. That act of trespassing, combined with the purpose of obtaining information, constituted a search all on its own. The warrant was invalid, so the search was unconstitutional. It was a clear, propertivist argument. Scalia famously wrote, "The government physically occupied private property for the purpose of obtaining information." We have no doubt that such a physical intrusion would have been considered a search within the meaning of the Fourth Amendment when it was adopted. But that wasn't the end of the story. While all 9 justices agreed that the search was illegal, 2 powerful concurring opinions from Justice Sotomayor and Justice Alito showed that the court was thinking far beyond this single case. Justice Alito, joined by 3 other justices, was uncomfortable with Scalia's property-based approach. What if the government didn't have to physically touch the car? What if they could track you using your cell phone's location, or a network of traffic cameras, or a drone? Alito argued that long-term GPS monitoring, even without a physical trespass, violates a person's reasonable expectation of privacy. He argued that the sheer quantity of data collected paints a picture so intimate that it reveals family, political, professional, religious, and sexual associations. He wrote that society's expectation has been that law enforcement agents and others would not and indeed, in the main, simply could not secretly monitor and catalog every single movement of an individual, esca for a very long period. Justice Sotomayor went even further. She agreed with both the property-based reasoning and the privacy-based reasoning, but she wrote a separate, forward-looking concurrence that has become incredibly influential. She warned that the government could easily get this kind of information from third parties, like our cell phone providers or our car manufacturers, without ever trespassing. She argued that the entire legal framework needed to be reconsidered in the digital age, where we voluntarily share immense amounts of personal data with private companies. Her opinion was a wake-up call, suggesting that the very idea of what is private and what is public is being fundamentally reshaped by technology. She basically said, this case is easy, but the next ones won't be. So what does United States v. Jones mean for you today? It means the police cannot just walk up to your car in a parking lot, slap a GPS tracker on it, and monitor you for a month. To do that, they need a valid warrant supported by probable cause. This case established a critical protection for your physical property against government surveillance. It affirmed that your car is an extension of your private sphere, but the case also opened up a much larger conversation. The concurring opinions of Alito and Sotomayor laid the groundwork for future legal battles over digital privacy. Just a few years later, in Carpenter v. United States, the Supreme Court ruled that the government also needs a warrant to get historical cell phone location data, directly citing the reasoning from the Jones case. The mosaic theory, the idea that collecting many small, public pieces of data can reveal a private, detailed picture of your life, is now a central part of privacy law. Antoine Jones, the man at the center of it all, eventually had his life sentence thrown out. After a long legal journey, he took a plea deal for a lesser sentence. But his case created a ripple effect that touches all of us. Every time you get in your car, the principle established in U.S. v. Jones protects you. It ensures that your movements are not an open book for the government to read at its leisure. It affirmed that even in a world of ever-advancing technology, the core principles of the Fourth Amendment, the right to be secure in our persons and property against unreasonable searches, still hold strong. The battle for digital privacy is far from over, but this case was a monumental victory for individual liberty. It proved that sometimes it takes the case of a suspected criminal to secure the rights of every citizen. Thanks for watching. If you found this case as fascinating as I did, make sure to like, subscribe, and hit that notification bell for more deep dives into the cases that changed our lives.